Hi there. Hello. Welcome. Disability Law Show. Good to have you with us again this week. I'm John Scholes. With me, James Fireman, Sivan Tumarkin from Samfiru Tumarkin LLP. Just happen to be the most positively reviewed law firm. You can Google that anytime you would like and back me up on that information. Here's how you reach out to the guys anytime as well. 1-855-821-5900. Email is help@disabilityrights.ca. There's some more contact information we will give out throughout the show. And our main topic in just a little while is going to be what you should know of suffering from addiction and applying for LTD. That is coming up shortly, but we always start off with the week that was, kind of a case of the day thing. And for that one, I think we're going to one of you guys. James will do it this time.
Why not?
Why not?
So I want to talk about a case that I've been dealing with recently. My client is a gentleman who worked in the oil fields for many, many years. He's been working heavy manual labor jobs with heavy equipment. And he had a back injury that became worse over time. And he's the type of guy who, isn't going to the doctor unless there's no other choice. And literally the day he stopped working, he had to be helped out of his equipment, and he was in tears from the amount of pain. That's what he was enduring. That's the point that he went up to. And so when he got assessed, it was very clear that he had significant injuries in his back. The medical imaging confirmed that. And over several years, he was on long-term disability. And finally, he went to a pain specialist who started giving him these facet joint injections that it's basically putting like steroids into your body, meant to give you at least a temporary relief from the pain. And that's exactly what it did. It gave him some temporary relief. And that really wasn't going to get the job done. And so then he started getting what they call radio frequency ablation. And if I understand the medicine correctly, essentially what they're doing is they are burning the nerve endings to essentially numb the pain. But it's something you can only do about every 6 months, and even that is only going to provide temporary relief. Right. A little bit longer than the injections, but still it's only temporary. And so what happened is after he got the ablation, the burning of the nerve endings, he was actually feeling pretty good for a little while. And he jumped the gun a little bit, and he said, okay, well, I got to get back to work. Yep. Even though he's getting long-term disability benefits, he doesn't want to stay home. Yeah. He's just that type of person. Exactly. Yep. And so he goes to his doctor and he says, I'm feeling great. This really did the trick for me. It's a couple weeks after he gets this procedure done. And he says, I want to go back to work, but they say that I need medical clearance first. So his doctor says, well, okay, I can clear you for light duty. I can't go anything further because you still have the same issues in your back. It's just you can't feel it right now. And so his work, it's fortunate for him, his work said no. And sure enough, within a couple of weeks, the pain comes back. And he goes through this cycle again of injections and the radiofrequency ablation, and it's even less effective the next time around. But the problem is the insurer gets that in the file eventually, that he tried to go back to work. And the doctor approved him for light duty. And so what do you think they do?
They latched onto it.
They latch onto it and they cut him off. And so fortunately, I was able to get all the medical documents and piece it together and be able to say, okay, listen, yes, he did ask to go back to work, but this was a couple weeks after he got his nerve endings burned. Right? Like, let's understand what was going on here. It didn't mean he was better. And of course, the subsequent record showed that the pain came back and it was significant. And there really wasn't much of a dispute that this guy is just in far too much pain to be able to sit or stand for any prolonged period of time. And so it worked out okay in the end. We were able to get a good resolution in that case. But I say this because I want to say this as a warning to anybody out there who's watching, who's in the same situation. And I'll tell you, as a firm, as a lawyer, I certainly prefer clients who are motivated to get back to work. I want clients who want to get back to work. Those are the type of people that I want to help. But be careful. Do not assume that just because a new treatment is working initially that it is going to be something that is a panacea, that is going to solve all of your problems. Make sure you've spoken with your doctor about the timelines before you start making those kinds of decisions. And I would make sure that if you're asking your doctor for that kind of a letter that's allowing you to attempt to return to work, that your doctor is careful about the language that they use. And as opposed to just saying he's cleared for light duty, it would be far preferable if the doctor had said, after having this procedure, he may attempt light duty, but if the pain returns or becomes sufficient, then he should stop. that obviously would have been much more useful and would have been something that the insurer would have had to recognize as preventing them from latching onto to deny the benefits. So I say this to anybody out there who is motivated to return to work. Yes, you should be. And if you are legitimately no longer disabled or feel like you might be able to return to work, talk to your doctors and listen to what they have to say. Don't push forward just because in the moment you're feeling okay. Make sure that you're set up in a situation that is going to be most likely to be successful for you.
Going back is, I would say not going back to work, going back on disability if needed to. Don't they have something called a recurrence clause? I mean, I don't want to get into the weeds of insurance policies, but don't they all have that? And that can't be triggered and should be kind of relatively smooth, no?
It should be.
Right.
It's not. What you're talking about, John, is that the vast majority of policies, certainly every policy I've looked at, has this clause that says that if within a certain period of time that you've tried to go back to work, you fail, you're not actually ready, you should be able to go back on long-term disability without the initial elimination period, that period of time where you don't get any benefits. Unfortunately, for the reasons that James explained, insurance companies often take the position, no, you're ready to go back to work. Maybe you didn't try hard enough, you didn't give it a good go, your doctor's wrong, whatever it is, and so they'll stop paying you. Again, we help people with those cases, we can resolve these things, we do deal with them, but everything James spoke about here reminds me of really two things, two lessons that I came away with from that case, but also many other cases, which is that insurance companies are notorious for cherry-picking information in medical files to suit their own narratives. And number two, they take statements out of context. And I can tell you, doctors get extremely frustrated with this. And they don't know what to do. And we get calls sometimes from doctors who are asking us what to do. They don't breach patient-doctor confidentiality, but they ask us. And in fact, we do some seminars for healthcare providers, and we talk to them for free to arm them with the information that they need so that they can help their patients deal with these insurance companies. And of course, sometimes they end up referring these patients to us so that we can help them from a legal standpoint. The point is this: there are remedies, there are things we can do. The insurance company is not omnipotent. They can't simply do whatever they want. But you need the expertise, you need that know-how, and that's where we come in, because we can help people understand what their rights, and we can help healthcare providers understand what they can do to help their patients with insurance companies.
Along those same lines, though, it's something you said, James, I thought was interesting. You mentioned, can go back to light duty as opposed to may attempt light duty if it doesn't work, so on and so forth. It was a little more complex, the explanation you would have preferred. Not in a million years would you guys ever coach a doctor on what to say. You're not doctors, they're not lawyers. But when they come to you, can you provide some sort of guidance in that way? Because so those mistakes don't happen, right?
100% we can, and we do. The dividing line, what we can't do is tell a doctor what their opinion should be.
Right.
We can't tell a doctor, it would be really helpful if you told us that he was actually disabled, even if you're not sure. We could never say that. And in a million years, nobody at our firm would ever even consider that. What we can do, though, is we could tell a doctor it's important to make sure that you discuss not just whether or not they can go back to work, but what the restrictions and limitations are. We're not going to tell the doctor what those should be or whether there should be any at all. But to include, to make sure that they are including all of the elements that are necessary to assist their patient through the insurance process, we can absolutely do, and we will do for doctors that call us and have done many times in the past.
Yeah, you're not trying to influence. I have a Casio. You're not trying to influence by any stretch, right? So, but you're there for advice for sure. A website called pocketemploymentlawyer.ca. Yeah, we usually bring it about, and it comes into play on the Employment Law Show and your partner Lior show. But it also has a disability function to it, doesn't it, Sivan?
It does, John. And of course, yeah, we do obviously employment law as well as disability law at the firm. Those are the two areas of focus that we have. And so we had created this website a long time ago for individuals who simply want to get quick and fast and accurate information about their own specific case. It customizes an answer to your specific situation, be it in employment law or disability law. And oftentimes they're intertwined. You have somebody who has issues with their employment. At the same time, they also have an issue with their long-term disability or short-term disability insurance company, and vice versa. And so they want to get this information. So you go to that website, pocketemploymentlawyer.ca, and you get this information. You basically input a few answers. You don't put your name or your phone number or anything like that. This is anonymous, and it's free. And then within seconds, you get a customized answer. If at that point you want to reach out to us, click the button, and we'll get connected. Otherwise, close the browser. We will never know you were there. But the key is accuracy, anonymity, and for it to be quick. That's what people want. So don't just go and Google the answers, because you're probably going to get wrong answers.
DisabilityRights.ca, yet another website that'll take you to the firm's website, DisabilityRights.ca. Once you're there, you can find the media tab will direct you to radio stations pretty much across the country where we host our radio shows. Sivan, James, and I, and Tamar, we're all over it. And from those radio shows, get a lot of phone calls. People want to call in and ask questions. I'd like to play them back here sometime as well, guys. So we'll get to our first phone call for this show right now.
He went off on disability and then became permanently disabled, and he's been away from his job for 14 years. Almost 2 summers ago, he had a double lung transplant. Well, the insurance company now knocking on our door saying, are you going to come back to work? And he worked in a type of job where it was a paper business, so there was a lot of fibers and inks, and he doesn't know if he has a leg to stand on or not.
So it's a very interesting scenario here, and it's not one that we come across all the time. Mm-hmm. So the caller's husband has been on disability, has been getting LTD for 14 years.
Wow.
For 14, that's a real long time because of a double lung transplant. Now, I'm not going to pretend to be a doctor, but a double lung transplant sounds pretty serious to me. And I would expect that if it is a condition that has disabled him for 14 years, unless there has been some new development in medical science, some new drug that he's been given, or some new procedure that has all of a sudden allowed him to regain significant function that has been absent for the last 14 years, it's hard for me to understand how his disability would have changed. And keep in mind, after the 2-year mark, when it becomes the any occupation test, where the disabilities are paid or not, if you're disabled from any occupation, you're entitled to benefits. That happens after 2 years. This is 12 years into the any occupation phase. So the insurance company has clearly agreed for a very long time that this person is disabled from any occupation, understandably. The onus of proving whether he's disabled or not is on the insurance company. Once they have approved you into the any occupation stage, if they want to change your disability designation, they want to say that you're no longer disabled, it's up to them to prove it. And how are they going to be able to prove it? I mean, listen, I haven't looked at the medical file in this case, so maybe there is something out there, but I find that pretty hard to believe. What is far more likely, my guess here, is that there's been a new claims handler put on the file. Right. And the claims handler said, you know, I'm going to take a shot at this. I'm going to see if maybe I can say that this guy can, you know, go to being a telemarketer because he could do it at a home. And what I will say is one thing that has changed recently has nothing to do with this caller's husband. It's that there are more jobs available that you can do from home. That is a legitimate position for an insured to take to a certain extent, but it's going to be very difficult in these circumstances to suggest that someone who has not been in the workforce for 14 years, who's had a double lung transplant, who's been disabled from working, is now all of a sudden capable of any occupation.
I know we got a break, but quick question. Does the concept, or at least the rule of commensurate income, still come to play 14 years out? Because the telemarketer, compared to his other job 14 years ago, probably not going to pay as much?
Yeah, although, again, that is a factor that could, in theory, be working against him, assuming there's not a cost of living adjustment into the policy, because it would typically be based on the commensurate earnings level at the time he became disabled. So with inflation, it's possible that that's how they're taking the shot. That's actually a really good point, John.
All right, we'll take a short break. Coming up, can you apply for LTD if experiencing substance abuse and addiction? We'll tackle that after break. The phone number to reach these guys anytime and their team, 1-855-821-5900, and help@disabilityrights.ca. We're coming right back.
People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca.
Alrighty, welcome back. Thank you so much for hanging in. Disability Law Show. You can reach out anytime for a private and lengthy conversation with either James or Sivan or a member of their team. The phone number 1-855-821-5900. Email is help@disabilityrights.ca. Guys, let's dig into our topic for this show. What should you know of suffering from addiction and applying for LTD? First point, in most disability policies, addiction and substance abuse is considered a disability. How about that?
Yeah, I mean, that is absolutely correct, John. And, we have seen policies where it's not. But in reality, even under the human rights codes of most jurisdictions across the country, in fact, I think all of them, things like alcoholism, for example, is considered to be a disability. And so if an insurance company simply says that because you suffer from this condition, even though you can't work, we're going to not approve your LTD, I mean, they're going to have a tough time justifying that, and frankly, we can resolve these kinds of claims. We've done that in the past. Where we typically see more resistance is in the second point that we're going to get to, but it is important people understand, especially now when you're having more of a crisis with medications and opiates, and things like that, where people become addicted to various kinds of medications, and then obviously are unable to work because they do become disabled as a result. They do have these run-ins with insurance companies who take the position that somehow they're not disabled or that they don't qualify under the LTD policy. And we tell people, listen, contact us, let us review the policy, review the medical documentation. We should be able to help you.
So I just want to stay on this point for 1 second before we move on in the list. So we know that we have people from insurance companies that watch our show for varying reasons, but not all of them is because that they don't like what we're saying. And I can tell you this because there's one person in particular, I'm not going to say who they are, where they work for.
But you should.
No, I won't. But this particular person,
we'll do it in the outtakes.
This particular person asked me if on a show, on one of our shows, we could talk about addiction, because it is an issue that is of particular importance to them. And so, and what the point was that they were trying to get across is that people who are suffering from addiction very frequently don't even apply for long-term disability, either because they don't perceive it themselves to be a disability, or because they're embarrassed by it, or because they don't want to let anybody know that they have a problem. So, there isn't a lot that I can do from my position to help somebody get over the issue of embarrassment, other than to say that I hope that you can. I hope that you can take that first step and apply for the benefits. And that is the first step. If you are suffering from addiction and that is interfering with your ability to work, then you're entitled to disability benefits, and you absolutely can and should apply for disability benefits. And if the insurance company denies your claim, and they very well might, you should be prepared for that. But if they do deny your claim and you're in a position where now you don't know what to do, well, here's what to do. You give us a call, because we deal with addiction claims all the time, and it is something that you're absolutely entitled to.
That point, James, kind of dovetails nicely into the second one, which you briefly mentioned, Sivan. That is continuing and complying with recommended treatment is absolutely vital.
Yeah, and certainly from a legal perspective, which is what we're talking about, but obviously from a medical perspective, that's critical as well. But I do want to throw a caveat there, because we know that people who are suffering from addiction issues will relapse, and that happens routinely. But does it mean because you've relapsed that all of a sudden you're not in compliance with your treatment and you're not entitled to benefits? Well, I can tell you insurers will often suggest that that is the case, but it is absolutely not true. The law does not consider that to be non-compliance. Now, if you are just refusing any kind of treatment and you're saying, no, I'm just going to dig into my addiction and I'm just going to let that go, well, then probably you aren't going to be entitled at that point. But if you are trying to comply with treatment, if you are doing whatever is recommended by your medical team, if you're going to the meetings they suggest, taking the medications, if they suggest inpatient treatment, whatever it is, if you are taking those steps and it's imperfect, you're trying, but you've had a relapse or even a few relapses, that does not mean the insurer is entitled to deny your benefits. It does not mean that. The law has said this over and over again. And if you've been cut off for that reason, you give us a call and we can fight that.
Again, talking about suffering from addiction, applying for LTD. Number 3 is this: insurers often misunderstand the nature and complexity of addiction and denying claims.
Yeah, and I'll start off from what James said previously, which is I'm not a doctor. But I can tell you I've spoken to enough doctors who specialize in addiction, and they'll tell you that it is a fairly complex condition, and it varies from person to person. People are obviously individuals, and they react differently, and sometimes they develop secondary conditions, oftentimes associated with mental health illnesses as a result of the addiction, oftentimes physical types of conditions. I mean, think about alcoholism and what that does to your liver and other parts of your body. And again, that is all intertwined. And to James's point about falling off the wagon sometimes, relapses, again, this is very complex. It's not just like, having cancer or arthritis or some other illness that we hear about a lot, and sort of people say, okay, yeah, we believe that you are disabled. With addiction, it can be a full gamut of symptoms. The nature of disability varies widely depending on the individual, depending on the kind of work that they do. And a lot of insurance companies and adjusters just take a very kind of simplistic view and approach to, not all of them, by the way, but some of them take a very simplistic approach to the frustration of treating providers. And I remember this one case talking about noncompliance or relapses out in BC, this young gentleman who was a high earner. And I remember he came to us and he was denied several times long-term disability because of relapses. And I remember even one of the lawyers in my office said, is this something we can help with? And I said, absolutely, but I want to talk to his doctor first. And so I got in touch with his doctor, family doctor, who also happened to be an addiction specialist. And she explained to me that he's absolutely in compliance and he's following a path that she has seen time and time again with these relapses. And again, she explained to me the complexity of it. And I said, okay, can you put this in writing? Can you explain this? Just dumb it down. Make it simple for me. Let's make it simple for everyone. Explain exactly, and then explain your background so that they understand that you know what you're talking about. And she did that. She did that once and then 2 times. We resolved that claim, which was denied, I think, 2 or 3 times by the insurance company for over $200,000. Wow. I mean, my client was he was homeless at that point. So my point is, these are complex cases, but they are cases that we have successfully worked on. Insurance companies, once you explain to them what their potential liabilities are, if they keep up the resistance, they understand that they have to pull out their checkbook and actually pay. But you need somebody on your side to help you do that, especially somebody who's an addict, who is struggling with that. They don't have the ability at that point to take on the insurance company. That's where we come in, and that's where we can help.
We'll take a short pause, and on the other side, do you have to follow insurer-recommended treatments? That is on the way on the Disability Law Show. In the meantime, number 1-855-821-5900, help@disabilityrights.ca. Coming right back.
People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca.
Welcome back, Disability Law Show. A few minutes to go, so I think we'll get into an email here, guys. Anytime you want to send one along, it'll be answered by James or Sivan or a member of their team. help@disabilityrights.ca. And the phone number, 1-855-821-5900. This time it's Eli, guys. Says, my sister recently started seeing a doctor recommended by the insurance company. Her treatment regimen seems to have lessened considerably, and now she's on medications that have serious side effects. The insurer says that if she refuses a treatment, she'll be cut off from her benefits. What can she do?
Yeah, I'll tell you, John, I know we kind of joke about the appeal being my biggest pet peeve around insurance companies, but if appeals are number one, this is number two with a bullet. Insurance companies getting in between the doctor-patient relationship and inserting themselves into the treatment protocol, that bugs me to no end. They cannot do that. What we say repeatedly on this show, on all of our radio shows, the number one thing that you have to be looking out for is your health. 100%, this is what I will advise every single person. Whatever the legal consequences are is secondary, and we can help with that. But first and foremost, take care of your health. And what does that mean? It means relying on the people that you can trust. And that's not doctors who are hired by an insurance company that has a vested interest in finding a way to be able to justify saying that you're no longer disabled. It is relying on your treating doctors who swear an oath to make sure that they do you no harm, that they are looking out for your best interests. So first and foremost, listen to your own treating doctors, please. If your doctors are telling you that you need this treatment and you need these medications, then that is who you listen to. If your insurance company wants to add to that or is suggesting something else, they're entitled to make those suggestions, they're entitled to their opinion, and they're entitled to cut you off if they believe that your doctor is wrong. But that doesn't mean you have to agree with them. If the insurance company has a different opinion than your treating doctors, then you take the insurance company's opinion and you bring it to your own doctor. And you have your own doctor look at it and review whether or not what the insurance company is suggesting is appropriate. And if your own doctor agrees, then by all means, if this new treatment that they're suggesting is appropriate, by all means go ahead. But if your treating doctor says, no, you should not be taking this therapy, or you should not be taking these medications because these side effects are dangerous, then you should not be taking it. And have your doctor put that in writing very clearly, that not only is it inappropriate, but it's going to have negative consequences and is not something that they can possibly recommend that their patient ever takes. Give that letter to the insurance company. If they still decide to cut off your benefits, despite the fact that they have been told by your treating doctor that it's inappropriate, then they have just opened themselves up to enormous punitive damages. And if that's the situation, then so be it. If it requires you putting your insurance company to the test and risking them cutting you off, then so be it, because you have to protect your health. You absolutely need to do that. And I understand that people live in a world where they have to pay their bills and they want to extend getting their benefits as long as they possibly can. And I agree with that. I think as long as you can reasonably do what the insurance company is asking you to do, even if you'd prefer not to, I think people should try to comply with what the insurance company is asking. But there is a limit to that. And when it starts getting into taking medications that have serious side effects and that your doctors disagree with, you're way past that limit. Way, way past that limit. So please prioritize your health above everything else. Let us help you with whatever legal consequences result from that.
And this could bite them in the rear end, because their suggestion or their demand to take these medications and now causing side effects, it could prolong the case. This person's on LTD. It's not going to help the insurance company at all.
Yeah, absolutely. But I don't even want to think about that. I mean, you're right. It could wind up happening that way. More often than not, though, what winds up happening is they'll suggest something that's more of a Band-Aid, something that will help you in the very short term, but is not something that's either sustainable or something that may have very serious long-term side effects.
That's a wrap, guys. It's a good show. A lot to unpack there. And always, you can contribute to the show anytime. Just send in your emails as well, either through help@disabilityrights.ca or mydisabilityquestions.com. You can use that anytime, free and anonymous. And the phone call works. Call these guys. Call their team, 1-855-821-5900. Again, 1-855-821-5900. And we will catch you next time right here on the Disability Law Show.